Hi, my name is Mariana. I'm a partner in Dynamo. I joined Dynamo in 2007. And today I'm going to share some thoughts about fast track possibilities in Brazil. The first thing I would like to share about fast track in Brazil is that the fast tracks are not limited to the examination procedure. When you ask for a fast track route in Brazil, when you, for example, ask for a change in the address of the applicant, or any kind of annuity, or any kind of action you take in the case, it will also be expedited. Not only the examination, but all the procedure will be expedited. And today we are going to, my first topic will be the patent prosecution highway. The patent prosecution highway is phase 2. It started in the beginning of this year and it went on 2024. And we have several countries and regions now that's part of the PPH program. It started as a very small program of the Brazilian PTO, just with some technical fields like the chemical areas, like the mechanical area. Now it's embraces all the technical areas and different countries and regions, as you can see in my slide. Most of the big countries like US, China, Europe, Japan, and UK are also part of the Brazilian PPH program. The requirements are very simple. If you have a PCT application, the international patent application must be published. Of course, you have to request the substantive examination before asking the PPA to enter in the PPH program. The substantive examination cannot have started. What this means? It means that if you have an offsection in the case, a technical offsection issued for the case, you cannot ask to enter in the PPH program. You have to request it only when the examination has not started yet. So our advice is to request to enter in the PPH program right after requesting the examination. And the deadline to request examination is 36 months after the filing date. If another fast track examination has been published, you cannot ask to enter in the PPH program. And you have some restriction, like the moment you can voluntarily amend the application, or you can file division application. I will share some slides regarding this item because it's very important in Brazil, because we have a very strict position regarding amendments and division applications in Brazil. So I have 2 more slides about this topic. And of course, if the patent application is the subject of a lawsuit, you cannot ask to enter in the PPH program. The subject matter have to be considered technical by a technical substantive numeric examination by a patent officer, which means you have to get allowed or granted decision by a partner office. What is important? The priority of the patent officer of the priority and the patent officer of the patent granted claims both have to be in the PPH program. So if the priority is a US priority and you got, for example, Japanese claims, or your PPH is okay, both have to be partner offices, the partner of the country of the priority and the country that you are going to base the application to request that enters in the PPH program. The subject matter that you ask to enter in the PPH program, has to be more equal or restricted than the claims of the granted claims or allowed claims by the patent office, which means if you have US granted claims for a method and a system, you can request examination and enter in the Brazilian PPH program with your US claims, only claim the method and the system, only the method or only the system, but you cannot ask the PPH program with method claims, system claims, and product claims, for example, because product claims was not considered patentable by the US Patent Office. So you have to pay attention because your claims has to be equal or more restrictive than the claims you are used as basis to request the entries in the PPH program. Some rules about the PPH program. The applicant has a chance to request one for the people enters in the PPH program for one application per weekly cycle, which means Monday to Sunday. 150 cases per IPC section and 1,600 cases per year. The best practice regarding the filing of the division application is you have to file a division application before requesting the examination, or in case the examination has already been requested, you should file the division application before enters in the PPH program. And I will share with you some thoughts regarding amendment and division applications in Brazil and why it's so important to pay attention of the moment you request the division application and the moment you request the examination. Before requesting examination in Brazil, you can freely amend your set of claims based on everything that is disclosed in the application as originally filed. The same is valid for the division application, which means if you have a specification disclosing a method, a system, a product, and different kind of products, everything can be a matter of amendment or matter to be claimed in the division application. After the request of examination, you request the examination considering a set of claims. This set of claims will be used as basis for all the amendments and division applications you have the opportunity to file or to amend after that date of the examination request. What does it mean? It means that when you decide to request examination based on a set of claims, only limited amendments can be used to amend your patent application. You cannot include another category of claims. You cannot change the scope of protection. You cannot broaden your claims. And the same is valid for division application. If you have a set of claims with a method claim and a system claim, for example, you are only allowed to file a division application related to the method claims or the system claims, and you should also withdraw the matter that you're going to include in the division application from the patent application that is pending at the Brazilian PTO, which we consider the parent application. Consider all these limitations. You have to pay attention on what time you're going to request an examination and what set of claims will be used to enter in the PPH program. After requesting request examination, and after choosing a set of claims to continue the prosecution in the PPH program, the set of claims should include everything that's important for your case. And that's why if you have US granted claims with a method claims and a system claims, and you also want to protect a product, for example, which was not considered a allowed claims in the US, you should file a division application for the product claims before requesting examination and before opting for amend the set of claims to continue enter in the PPH program. That's a very important limitation of the PPH program in Brazil. here I have a timeline with also this important practice regarding the division application. We have several steps of the patent prosecution in Brazil. You file between step 1 and step 2, which means filing the application, request examination. You are free to amend the set of claims in the application, and you are free to file division applications. Consider that the matter should be disclosed in the application as originally filed. After request examination and between the PPH request, which is between step 2 and between step 3, only restricted amendments can be used, and division has to be based on the set of claims for which the examination was requested. So the limitation that I explained in my last slide is valid here between step 2 and step 3. And it's always another restriction here. After requesting to enter in the PPH program, you cannot file division applications and you cannot amend the claims between you receive a response from the Brazilian PTO if your PPH request was accepted or not. So between step 3 and step 4, or between step 3 and in between step 3 and step 4, you cannot amend the claims and you cannot file division applications. You have to wait a response from the Brazilian PTO regarding the acceptance in the PPH program. After the acceptance or the denial, which between, if your case was accepted, so between step 4 and step 5, you also have to wait the first stop action to amend your claims or to file division applications. Why? Because the first stop of section will analyze the case for which the PPH request was pending at the time the PPH request was interest in the PPH program was requested. So only after the first stop section the applicant will be allowed to amend or file division application. And if in case the PPH is denied, the patent application will have a normal route, or you can amend and file division application. Consider that same limitation I explained in my last slide, which means only restricted amendments, and divisionals you have to be based on the claim sets pending the patent application at the time the examination was requested. I know it's a really bit complicated. It's not easy to understand, and it have a lot of details, but it's very important to consider these steps in Brazil and how to amend, how to use the PPH program without jeopardizing the protection we want in Brazil. The second resolution we have about fast track examination in Brazil is Resolution 294. This resolution is about two different topics. The first topic is related to the applications covering technology which is available in the Brazilian market. What is that? All the technology that is available in the Brazilian market, which is related to a patent application, with an object that is claimed in a patent application, can be object of a fast-track examination. The object claimed had to be licensed, offered for sale, imported, or exported in the Brazilian market. How do you prove it to the Brazilian PTO? You can send the folders, you can send websites, links to websites showing that your product is being sold in Brazil, is being licensed in Brazil, comparing the product with the claimed object, and then you ask for fast track route in Brazil, and your fast track route will be accepted. Also, if the invention is related to activity, invention is related to a object of activity founded by the Brazilian government, not application filed by the government support entities, you also have to be right to request a fast route examination in Brazil. The difference from this resolution, for the first resolution, which is related to the PPH program, is that this second resolution, you can request the fast track at any time during prosecution of patent application. So what does this mean? If you have a first objection, a second objection, rejection decision, that doesn't matter. You can also request a fast route examination in Brazil if a patent application is covering that kind of technology or is founded by a government and application filed by a government exported entity. What are the remarks? One patent application per applicant for each weekly cycle, the same as the PPH program, 100 cases per IPC section, and also 400 cases per year. The last resolution I'm going to share is resolution 247. This resolution embraces different kind of fast track possibilities, but I choose the ones I consider most important and are the most relevant in Brazil, and you can also have the opportunity to use it as a patent attorney. The first one is the applications covering a therapy to the following disease like cancer, HIV/AIDS, and negligence and rare disease. You have only to file a petition to the Brazilian PTO proving that your application is related to one of these cases, and you request the fast track examination. And the problem, the problem, the Brazilian PTO will very quickly issue a accepted decision and examine your patent application. If your application is covering subject matter that is reproduced by a third party without authorization, well, which means you believe that your product is being infringed, this is necessary. A very simple way to request the expedited examination. We have to prepare and send a warning letter to the potential infringement and submit some kind of proof of the potential infringement. For example, a packet of the generic drug, a website link proving that someone is offering a product that infringes on a patent application in Brazil, any kind of folders offering a infringement product, any kind of proof that your patent application is being infringed. The third one is the application seeking protection for a green technology, such as alternative energy transportation, energy conservation, waste management, and sustainable agriculture. It's also very easy to prove. You have to choose to prove that the green technology related to for example, with the specific IPC classification. Maybe you can demonstrate using some parts of the specification or some claims that your technology is related to that your invention is related to a green technology, just to relate your patent application to a green technology. You have some limitations like the number of claims, maximum of 3 independent claims. So sometimes you have to amend your patent application to request to enter in the green technology program. Also, the inventions related to pharmaceutical products and process and equipments and our materials for use in health for the example prophylaxis and treatment of COVID-19. It's a new topic of the Brazilian PTO resolution, which included all the technology related to COVID-19 in the possibility for the applicant to request expedited examination. If your application is claiming a Brazilian priority, it's very simple. You just file a petition proving that the patent application is claiming this kind of priority, and the Brazilian PTO accept your patent application to enter in a fast track examination. If the invention having a prior user, of course, you can also have a fast expedited examination. If your application was filed by startup as well as medium and small enterprises, and the last one, if the applicant's age is more than 60 years old. as well as if the applicant has physical or mental disabilities. This is important to say that the applicant's age, it's not the same of the owner of the patent application. This has to be an individual with 60 years old or more than 60 years old. The same as the last resolution, you can use at any time during prosecution of the patent application. You don't have a time limit to request the entrance of this, the possibility to enter in this kind of fast track examination in Brazil. Some important remarks. As you're probably aware, we have some kind of challenge, constitutional challenge that changed the term of patent application in Brazil. Since our new patent law and until the beginning of this year, the term was the term was at least 10 years from grant or 20 years from the filing date, which was the biggest one. So if the applicant has at least 10 years from the grant to have a patent in Brazil. This decision changed this understanding, and now only the patent claims are the patents in Brazil are only granted for 10 years from the 20 years from the filing date. The 10 years from the grant is no more valid in Brazil. So how we can expedite the examination? Consider that this time frame you have now a limited time frame in Brazil, and sometimes the Brazilian PTO has a huge backlog and takes some time to examine your patent application. If you consider that your patent application is pending for more time than you want in the Brazilian PTO, you can, for example, request you file a writ of mandamus with a preliminary injunction request. Ask the courts, it's not filed at the Brazilian PTO, it's filed in the courts of the Brazil, the federal courts of Brazil, in order to order the Brazilian PTO to conclude the examination and issue a decision on the administrative appeal within a reasonable time frame. If we identify that the Brazilian PTO will delay or take a reasonable time frame to conclude the examination of the administrative appeal. What does it mean? We can, if you believe your patent application is one of these cases, you can file some proof. For example, your patent application is related to a telecommunication. And you notice that most of the cases related to the telecommunications field is examined around 10 years or 11 years from the filing date. And your patent application is pending for more than 4 or 5 years in a second instance, waiting for a final decision from the Brazilian PTO. So we can file a writ of mandamus with this evidence that the Brazilian PTO is taking a lot of time to conclude the examination, and also comparing with similar patent applications which are in similar position of your case, to prove that the time delay in your case is unreasonable. In that you request the Brazilian PTO to conclude the examination, of your case. This is examined case by case, and that depends on the situation of the technical field, that depends on the area, depends if it's related to the first instance or the second instance. But if you have some doubts, or you believe you're taking so many time to conclude the examination, you can analyze your case. And this is a very simple way to try to expedite the examination in Brazil, is avoiding formal offsection. For example, you can avoid formal offsections by adapting the application to our local regulations before requesting examination. There are 3 simple rules that you can follow. Is inserting the characterized by expression in the claims, inserting the reference numbers of the drawings in the abstract and claims, and also harmonizing the title of the application with the preamble of the claims. You should do it because you avoid a formal off-section based on strict formal matters, and sometimes your patent application goes straight ahead to a technical examination. Thank you very much.